All right, so today we're jumping into a really big one. We're breaking down a major Supreme Court ruling that pits one of America's biggest cities against the nation's top environmental watchdog. Now, this isn't just some dry legal fight, It's about who's really responsible for the water we all share. Okay, let's get into it.
Yeah, it's a really tough question, right? But it's exactly what this case is all about. So picture this. You're in charge of a city. A massive rainstorm hits, your sewers just can't handle it, and suddenly, raw, untreated wastewater is flowing right into the ocean. Who's on the hook? Who gets the blame? And maybe more importantly, who has to pay to fix it?
So who's in the rink for this fight? Well, on one side you've got the city of San Francisco, and on the other, the Environmental Protection Agency, the EPA. Their entire battle, this whole showdown, it really all comes down to one single super powerful piece of paper, a water permit.
Okay, so to really get what's going on, you kind of have to understand how San Francisco's pipes work. See, like a lot of older cities, it has what's called a combined sewer system, and that's exactly what it sounds like. The water from your shower and toilet gets mixed with the rainwater from the streets. It all goes down the same pipe. Now, most days, that's totally fine. But what happens when you get a massive storm? The whole system just gets flooded. And when that happens, everything, and I mean everything, including raw sewage, gets dumped straight into the Pacific Ocean. And let me tell you, the stakes here they're just massive. We're not talking about a small fine, like a slap on the wrist. No way. In a similar case, the penalties being thrown around were up to $10 billion. Seriously, billion, with a B. So yeah, this is a very, very big deal. The whole legal fight really boils down to this one key term, an end result requirement. This is where the EPA, in a new permit, basically told San Francisco, look, whatever you discharge cannot, under any circumstances, violate water quality standards. Full stop. They didn't give them a roadmap. They didn't say how to do it. They just said, you have to.
Here's a great way to think about it. It's like your boss coming to you and just saying, make the company successful. That's the EPA's approach, this huge, broad goal. But San Francisco was saying, whoa, hold on. We need you to be more like the boss who says, make 20 sales calls today. See the difference? One is a vague outcome, the other is a specific task you can actually do.
So, to figure out who's actually right here, we've got to go back and look at the rule book for all of this, which is the Clean Water Act itself and how it even came to be.
Okay, so before 1972, the way we handled water pollution was, well, it was a mess. It was totally backward looking. You basically had to wait for a river to get super polluted, and then you try to hunt down who did it and sue them. It just didn't work. So in 1972, Congress completely changed the game with the Clean Water Act. They went for a forward-looking approach. The big idea? A permit system that sets clear rules for polluters before they can dump anything. And trust me, this little history lesson is absolutely crucial for understanding why the court ruled the way it did.
And that brings us right back to the central question, the big disagreement the Supreme Court had to solve. What can the EPA actually put in these permits? What can they legally demand? It's pretty wild. This entire massive case, with billions of dollars on the line, it all came down to how you define one single word, limitation. Sounds simple, right? But the answer would decide everything. So here's how the two sides broke it down. San Francisco was like, look, a limitation is a speed limit. It's a specific number. You know exactly when you're breaking the rule. But the EPA's argument was, nope, a limitation is more like telling someone to drive safely. It's a general goal, and it's up to you to figure out how to meet it. So, Justice Alito, writing for the court's majority, he basically bought the speed limit argument. He said a limitation has to be a rule that the regulator, the EPA, puts on you from the outside. He argued that just giving a big goal, an end result, forces the city to figure out its own rules to regulate itself from the inside, and in his view, that's not how the law was designed to work.
But there was a dissent led by Justice Barrett, and they had a completely different take. Their argument was pretty straightforward. They said, come on, telling a city it's not allowed to violate water quality standards, how is that not a limitation? It's a condition. It's a restriction. They argued it's just the plain, everyday meaning of the word.
All right, so you've got these two really strong, competing views on the table. So where did the Supreme Court land? What was the verdict?
Well, the verdict came down, and it was a clear win for San Francisco. The Supreme Court said, yep, the EPA cannot use these vague end-result goals in their permits. It's just not allowed under the Clean Water Act.
The court basically laid out three big reasons for their decision. First, they looked at the actual words in the law. Words like implement made them think the EPA is supposed to be giving specific instructions. Second, there was the history we talked about. Congress made a very deliberate choice back in '72 to get away from that old, messy system. And third, they looked at the structure of the act. They argued these vague goals would create chaos, especially when you have lots of different polluters on one body of water. It would just be impossible to figure out who's to blame.
Okay, so what does this actually mean going forward? Because believe me, this decision sends huge ripples out to cities, to companies, really to anyone who deals with water quality.
Essentially, this ruling hands the EPA a whole new playbook. From now on, they're the ones who have to do the heavy lifting. They have to figure out the exact steps a city or a company needs to take. They have to go out, get all the data to back it up, and then they have to write those super specific, concrete rules right into the permit itself.
So here's the bottom line, the big shift. The burden of being the expert is now squarely on the EPA. The agency can't just point to a finish line and say, get there. They now have to provide the map and tell polluters how to get there.
And this all leaves us with one last giant question to think about. On one hand, does this ruling protect cities from being handed impossible, vague goals they can't possibly meet? Or, on the other hand, does it strip away a really powerful tool that regulators need to keep our water clean? There are strong arguments on both sides, and the answer to that question is going to define environmental law for decades to come.